The feedback form will be sent at the end of the webinar, so you don't need to ask for it. It will be sent through mail. No issues with it. You need to be more clear, Sandra, please.
Good evening, everyone. I'm myself, Sandra. Ma'am, right now.
Yeah, go ahead.
Lawtraction India was formed in 2018 and is one of the countries which has free legal mentorship and counseling to approximately 1,000 law students, school students for all needed ones. Our team has guided many students in their project, home competitions, paper presentation, and many other such competitions. We try to pull their law to so that students can stay in their law school. On the other hand, Lawtraction has worked with many lawyers and different NGOs in different projects, which include education right, protecting right of child and women, and many awareness programs.
Sorry for the inconvenience. Lawtraction India was formed in 2018 and is one of the countries which has given free legal mentorship and counseling to approximately 1,000 law students, school students for all needed ones. Our team has guided many students in their project, moot competitions, and many such other competitions. We try to pull their load so that students can stay in the law school. On the other hand, Law Attraction has worked with many lawyers and different NGOs in different projects, which include education drive, protecting rights of child and women, and many awareness campaigns. We have across the country, worked together in multidisciplinary terms to provide full legal service guidance on the most complex legal matters and legal aid. This approach yields higher level of commitment and morale, yielding better results for them as well as the society. The pandemic has forced us to go online, and we have successfully adapted to the new changes, creating our social media accounts, which has successfully have around 2,000 followers us all together from all social media handles. In these few months, we have created a platform where we provide everyone information regarding internships, new article writing competition programs, knowledge about maxims, legal phrases, legal topics, etc., which helps the law students to be more updated and build new knowledge, according memes scrolling memes on social media platform and is providing services for solving anyone's doubt by just sending us one message in our social media handles, especially on LinkedIn. We are 24 by 7 active there in LinkedIn. With the clear mission and vision, motto, and goal, we have law attraction can be a powerful value adding asset for the student fraternity in India. We would like to strengthen to work more towards our endeavor to disseminate the legal knowledge by organizing various webinars, awareness campaigns, and etc. We welcome all the participants to the webinar. I would like to welcome our esteemed speaker to this webinar, ma'am. Ma'am is an advocate. Her name is Nishtha Sandhya. Ma'am is a practicing lawyer in the district court and predominantly in Delhi High Court. She is dealing with the cases pertaining to matrimonial offences, landlord tenants disputes, frauds relating to immovable property, specific performance to sell and contracts, consumer cases, economic frauds, and anti-corruption matters. Ma'am had come up with she's a merit holder throughout the duration of her graduation in law. She is an offer holder for LLM in IPR from reputed colleges like in London School of Economics and King's College London. She had specialized dissertation work in IPR during the graduation. Ma'am is also a partner of Vipin, Sandhya and corporations. Thank you, ma'am, for taking your valuable time with us today. Here we go for the most awaited event. I switch over to you, ma'am.
Hello, team. Thank you so much. And just a slight correction to the pronunciation of my name before I begin. So I am Nishtha Sanduja, and I am working as a partner under Mr. Vipin Sanduja and Company. And I'll begin. The topic in hand is fashion law. So whenever we talk about the word fashion, what is it that comes to our mind? It is clothing, which is apparel, which is also why this is called the apparel law. But alongside this fashion law includes within its ambit things like your cosmetics, jewelry design, all other kinds of accessories like your belts, bags, shoes, everything. Now, when we speak about fashion industry, what comes to our mind then? It is designers designing their clothes, models walking on the ramps, right? And what other kinds of things? We have the entire supply chain processes involved and as a part of the fashion industry, right from sourcing the textiles or the raw materials up till formation of not just a finished good, but then to present that finished good either on an e-commerce website or in the shops, then advertising them further. So now we have these social media influencers who often tag brands, they're wearing them. So that kind of advertisement is also a part of this fashion industry. Then everything that goes after the after sale services also form a part of it. So when we talk about e-commerce, after you have delivered the goods to the consumer, you also provide certain kind of return on those products. So all that forms a part of the fashion industry. Then a very eminent feature of this is the very eminent problem for basically the designers is that their rights get infringed, their economic rights get infringed. How? Because whatever designs they have created, they get copied. They get infringed via copying. So that is the primary concern. Am I audible to everyone? Any responses?
Yes, ma'am, you are audible.
Right.
Yes, ma'am.
Okay, all right. So I was talking about the fashion industry. So right from advertisements up till the after sale services, everything forms part of it. Then another thing that forms part of the fashion industry is labels. So when you purchase a product, you find these kind of labels attached to it that tells you that this is PETA friendly, this is environment friendly, or this is 100% cotton or linen, or these kind of labels that are attached. So there are certain international standards based on which you can claim these kind of labels. So that also forms part of the fashion laws. Now, when we consider fashion laws as a law-based field, we need to study multiple things. So we need to know intellectual property rights, which will help us preserve the creativity of all of these designers, the designs that they're forming, and the showcasing of those designs via ramp walks and everything that pertains. So that is one. Then contract law. A person specializing in fashion law needs to have a sufficient knowledge base of contracts, because there are so many things that have to be dealt with contracts, the employer-employee contracts, the modeling assignments and contracts. So everything involves contracts. Then labor laws are very important because be it be any industry, we require both skilled and unskilled labor. So labor laws, then taxation laws. So these kind of things also, as I told you, the international standards for varied labels. This is the cumulative knowledge that a person needs to have. Beyond litigation, they even need to know arbitration and these kind of alternate dispute resolution measures. Because mind you, when we talk about patents in specific, and we would be going much in detail after this, but when we talk about patents, not all the patent holders want to go into a litigation. Okay, because going into a litigation in order to claim for an infringement also means that they will have to disclose their entire invention during the entire process of the court. So they prefer things like arbitration in the first place. So a lawyer needs to be adept with all these fields of knowledge when one wants to specialize in fashion laws, right? Fashion laws has very high eminence and importance in India today, because it is contributing a lot to our GDP nowadays, right? So media law, fashion law, pharmaceutical law, these are the very relevant newer fields of law that are now existing. And for your master's degree as well, this is a very good course to pick up. So for this particular session, we'd be focusing more on the intellectual property rights part of it, since of course there is paucity of time. We cannot be discussing contract law, labor law, everything else also together. So we'll start right away with the intellectual property part of it. So intellectual property simply is any kind of creative work that is your brainchild, is your creative work, and that has an intellectual property right available to you in India. So anything that you create based on your own intellect, based on your own creativity, your own labor and skill goes into making it, that forms part of intellectual property. Now, the word only suggests that it is considered property in India. So just like you have rights over your movable property, your immovable property, similarly, you do have these similar kind of rights over your intellectual property. What kinds of rights are these? These are economic rights primarily. That means that the creation that you have done out of your intellect, that could be a book, that could be a movie, in the field of fashion, that could be a designer lehenga, these kind of creative things, they can get protected, and only you have the monopolistic rights to sell it off to someone or to license it to someone, these kind of economic rights, to reproduce it in any such form, to save it in electronic means or any other means. So you should have the rights for it. This is the intellectual property rights. Along with economic rights, you do have other rights also. We would discuss that also one by one when we start discussing the varied subject matters of intellectual property. Now, coming over to what is the purpose of protecting intellectual property? Why would India want to protect intellectual property? Am I still audible? I'm getting some notification.
Ma'am, you're audible.
You are
Okay,
audible.
right. So I was telling you about the purpose of intellectual property. Why would India as a country want to give you rights over your intellectual property? This is because when we start creating newer things out of our intellect, it enhances the GDP of our country. And it has been known, I'll tell you how, it has been known that all the developed countries in the world, they have a very strong IP base, intellectual property base, which is what makes them successful in the first place. Because what is their success? Technological advancements, industrial application of varied creative projects. This is what brings about newer ideas, newer projects, newer markets, right? And all this emanates from one person creatively creating a certain thing. So we have a higher good in protecting these IP rights also. Then a government, this Indian government or any other government also, they play a very major role in balancing these rights. Now, what do I mean by balancing these rights? See, whenever I as an individual have some rights, others have certain negative rights. They cannot leap over to my rights. That's the primary concern. But when we talk about IP, what the government needs is that along with GDP production, intellectual property should be purposeful to the general public at large. Now, how would it be purposeful to the general public at large? When monopolistic rights are granted to the creator, right, to the owner, the first author, these people who create intellectual property, but at the same time, these monopolistic rights are taken away from them after a certain point in time. Only then now the public will be able to use it, and that will not be considered infringement. So this balance the government maintains by having varied acts in place. So we have the Copyright Act, and these are the subject matters of intellectual property. Copyright, trademark, then we have your patents, then Design Act, geographical indication, trade secrets. Trade secrets is not a legislation here in India, but still it is a subject to be studied under the fashion laws and under intellectual property as well. Then we have biodiversity and plant diversity protection, of course, which is not a part of the fashion law. So we would not be discussing that, but it is a part of intellectual property. Furthermore, there are things like the Anti-Competition Act in picture 2002, and it is based, some of its provisions are based on the TRIPS agreement that India has signed. So, okay, must I mention this over here, that since India is a signatory of TRIPS, TRIPS is trade related intellectual property rights. It's an international agreement. And since you're signatory to that, do we have all of these laws pertaining to intellectual property? Meaning thereby, all the countries who are signatories to the TRIPS agreement have similar provisions like India has when it comes to its IP rights. Actually, this is also another reason why people prefer to specialize in IPR, because that means that to a certain level, they can adjust themselves in the field of practicing law in any country because the laws are pretty much similar. Then, so that all these owners, coming back to the IPR, so that all of these owners, the authors, the creators in the first place, do not really misuse the rights that are given to them, the monopolistic rights that they can only sell their products in any which way, or they can only reproduce them in any such form or whatever, so that they don't abuse the power. Do we have Competition Act in place? Do we have, I think it's section 27, I guess, of the Indian Contract Act, which also mentions that you cannot have trade and commerce needs to be progressed. So you cannot have agreements in restraint of trade and commerce. You cannot stop that entirely. So these are certain provisions to prevent abuse of power. And with that, coming back to the fashion law example. So now let's take an example of the Lakme Fashion Week. So say you have the Lakme Fashion Week. Now, based on all of these subjects of IPR that I stated to you, how can we protect Lakme Fashion Week? So the logo Lakme Fashion Week, along with its color scheme, that is a part of trademark. That'll get its protection under trademark. Now, if anybody infringes that, the rights of this particular author of whoever's created this trademark and the company Lakme Fashions, they can sue this other party for infringing their copyrights. So that's one. So Lakme Fashion Week, trademark under their trademark gets registered under the Trademarks Act. Next comes the fashion designer, the designs that they make. So the designs can be paper-based, that is 2D designs that are also copyrightable subject matters. Also the 3D versions of them, that is your costumes, which the fashion designers, which the RAM models are actually wearing. That is also copyrightable. Also, both these things can also be granted a design protection under the Design Act. You have to elect one, either the copyright protection or the Design Act protection. I'll discuss with you why. So that is how you protect the costume bit of it. And so which is why, okay, so if you're utilizing any varied kinds of textiles, okay, you have created a new textile, a very stretchable sort of a fabric or any newer category of a fabric, that fabric can get patented. Its process in itself can also get patented. So this is how you have an umbrella protection over your entire creative, creative expression. Right? So ideas don't have copyrights, patents, or any kind of IP protection. You require an expression of that, either in the form of a book, or in the form of clothing, or in the form of shoes. Any creative expression can get rights of intellectual property, and not a mere idea in your brain that you disclose, we have this particular idea, kindly grant me a patent for this. No. You need to show that it is industrially viable, it can be produced and come to use to others. So that is it. With that, I'll just take a quick water break and we'll commence with copyright law in the first place. Sorry. Coming over to the copyright law now. Asha, also the entire knowledge of all of these laws that I'll be giving you now, for lawyers and law students, this can be a recapitalization if you have studied this previously, or you could get to know better how could you, prevent the infringements occurring on your clients, and how can you give them a very bespoke sort of an advice that, that suits them and only them and not somebody else. So this is for them. If you're a fashion designer or a fashion-based student or a boutique owner, a designer yourself, this webinar is going to be useful to you as well, because then you would know firsthand without even having to consider any lawyer-based advice that you'll know the first step definitely, how to protect my creation, right? So starting with copyright law is something that subsists on original works. So it needs not be copied, it has to be original, innovative, and your own creation, indeed. Okay, then copyright, the subject matter of copyright is literary, artistic, musical, dramatic, architectural works, computer programs, these kind of things. But in the interest of fashion law, what is important to us when it comes to the subject matter, it is the artistic aspect of it. So copyright says that artistic things can be granted copyright. Everything in the fashion industry pertains to this artistic feature. So we'd be discussing this artistic feature in detail now. So what are the rights available to somebody who has created an artistic thing? It can be a shoe, a garment, everything. Keep your minds absolutely open. It can be cosmetics, anything. Now, what are the rights granted for the creation of this artistic work? It is economic rights, as I stated to you before. And now what forms part of the economic rights? You could create a 2D version of it on paper, and you could get that protected under the copyright law. Then you have 3D versions of it. Okay, you yourself being the author of this particular creation have all rights to reproduce the 2D version of it into a 3D version of it, meaning thereby literally everything, that whatever room or whatever place that you're sitting in, everything that surrounds you can become a matter or under this artistic works ambit and definition under the copyright law. Everything, literally everything. Okay, so that is part of the copyright. When we talk about the economic rights further, so you could reproduce them in any form in either 2D or 3D. You could sell them off in any form. You could license them in any form. You could assign them to someone. Assignment is almost like a sale. That is the thing. Also, you could issue copies to the public. You could give out certain clips to the news media. These kind of things for dispensing it out to the public. That those are your economic rights. You could adapt them also in a certain way, like you made a movie out of a fashion show and what went inside you doing and dealing with the fashion show. All of those are your economic rights. Coming over to moral rights. With copyright, the author gets something called the moral right. The author is known to be the parent of his creation. So meaning thereby he gets certain rights to protect his repute when it comes to the creative expression. It is often said that whatever you have created represents you yourself. It represents your personality. So these are called personality rights also. So the author has all rights to, if his paintings or if his designs are being mutilated in such a form, they're being objectified, mutilated in any such form that he himself did not want it to be presented to the public like that, he has all rights to raise objections to it. Now, there's a distinction between who's the author and who's the owner of copyrightable subject matters. The author is the person who's firsthand creating it. Okay, that's the author. And he, by default, under the copyright law, is the owner of it also, the first owner of it. But now, being the first owner, he can sell this further to someone. Now, whoever this particular artistic work has been sold to is now the owner of it. Okay, so the author is the designer who created the lehenga, but the owner is me who owns this Sabyasachi lehenga now. So that's the variation. If I have commissioned a boutique person to make a lehenga for me, right? So she has made the lehenga, she's the author of it. But I have commissioned that work and I'm paying her for those services. So I'd be the owner of it. So there's a distinction between owner and author. But mind you, it is the author who would always...
content to address to the needs of the industries and nice to content to address the...
Hello, what is this that happened? Can I continue further?
I'm sorry, ma'am. Someone has unmute themselves. I'm sorry, you can continue.
Okay, all right. So I was talking about the paternity rights. So the paternity rights, the moral rights, they always remain with the author. For example, if we talk about an M.F. Hussein's painting, I have purchased that painting. So I'm the owner of it. I can gift it to someone now. I can resale it, whatever. But if I'm mutilating it in some fashion, I am, concealing certain figures and making right to protect his creation. Similarly, Sabyasachi, all of these lehengas, whatever comes under the ambit of fashion law, all of these people also have this particular right. Coming quickly over to the next, which is neighboring rights. Copyright provides you neighboring rights as well. Neighboring rights are rights that accrue from the original creative creation. So in the case of fashion law, neighboring rights would be with the broadcasters who are broadcasting your fashion show. For example, Zoom TV is. So they are the broadcasters. What rights would they have? When all can they, repeat telecast your show? So those are the rights of the broadcasters. Then models who are walking on your ramp for these designers, they are also people who will have certain neighboring rights. It's not like that you could distort and mutilate their image also in the final fashion show that you record and then send it across to varied broadcasting channels. You can't do that. They have a right to represent their face, their image, their everything. So those are neighboring rights. Now we'll come over to the actual dilemma that people face when it comes to copyright. Now, copyright gives you a term of protection until your entire lifetime, plus 60 years after it, meaning thereby, after your death, your legal heirs could also utilize your creation, economically make it viable to themselves for another 60 years is period. There are certain exceptions to this. For example, the works of Mahatma Gandhi and all other national importance works, they are copyrightable until times immemorial. They have been consistently recognized again and again under the ambit of copyright. So, but for others, for the generic public, it is lifetime plus 60 years. Now, this means that this is such a lucrative thing that I'll be getting my protection for my entire lifetime, and my children would also get to utilize it. But that's not all. The designers still might not want to go under copyright protection. Why? Because under the Copyright Act, there is a section 15, that mentions that if your design is registered, if your entire creation, your artistic work, not design, is registered under the Design Act, then you will not get a copyright protection over it, right? And the second clause of it is what causes the dilemma to the fashion industry. And listen to this very carefully. If you have replicated your design and reproduced your design over more than 50 items, then copyright will not exist on your designs. Before I begin to explain this, let me mention another fact of copyright to you, that for copyright to persist in your work, registration of a copyright is not mandatory. Okay, the moment you have created some artistic work, copyright subsists on your work automatically. But why do people get it registered in the first place? So that if infringement occurs, it is easier for them to in turn prove that they were the ones who originally created it, and somebody else is basically the infringer who created this other thing later on. Okay, so just for that purpose, registration becomes mandatory, right? But when we talk about this particular section 15 clause 2, it mentions, so copyright will subsist on my work even if it is unregistered. But now if I've made a lehenga and I have sold more than 50 copies of it, now I have zero rights over my creation, because under the design law, if I haven't registered it, I don't get a claim. And if under copyright law, I hadn't registered it, or even if I have registered it, now that I've sold more than 50 copies, I don't have a copyright. So basically, I cannot go and claim anything. And a very relevant case law on point is of a very famous fashion designer, Ritu Kumar. So the case law's name is Ritika Private Limited versus Biba Apparel Private Limited. So Ritu Kumar, who's the plaintiff, she claimed that Biba Apparels, which is also a very popular Indian brand, they have indeed copied, they have made colorable copies of her designs, right? But the court in this case, Ritu Kumar had not registered her designs under the Design Act, which is why she was claiming it under the Copyright Act itself. So the court stated that she will not be granted any rights, and Biba in turn has not infringed any of her rights because she had already sold more than 50 copies of that particular design. Meaning thereby, if me being the designer, if I want to sell 1001 copies of my lehengas, my design, my suits, my shoes, whatever pertaining to the fashion industry it is that I'm making, I need to get better protection under the Design Act and not under the Copyright Act, even though copyright seems a very lucrative provision based on its term. You know, it's granted to you for an entire lifetime plus 60 years. with that, moving on to what will be infringement when it comes to copyright and what will not be infringement. Don't worry, don't feel that we're still stuck on copyright. We're not ready to any minute. This is three more than the other, and the rest of them are much smaller. So what will be infringement and what will not be infringement in the cases of fashion industry? So if you've, again, I'm choosing the lehenga word, a Sabyasachi lehenga, as my example, so that it's very clear that that's the very example, and we'll be discussing varied things based on the same example so that it gets more clear in your heads. So a Sabyasachi lehenga, we find so many replicas of these things, of LV belts. People say that these are first copies, second copies. So is that infringement or is that legal? That is a total infringement. The moment you copy paste the labels, the trademarks, and you actually sell them as those kind of copies, when you copy paste their labels also, that becomes an infringing copy. Okay. But at the same time, if you make knockoffs, now what are knockoffs? Knockoffs are that you copy the design, but you change the material to it, so that it can be made available to the general public. A Sabyasachi sort of a lehenga can be made available to the general public for a much lesser price. Okay, so this in turn, these knockoffs, what is this disturbance going on? I think whosoever's listening to this, it's Miss Priya. I think your audio is on. Please don't do that. It really breaks the flow of the session. Okay, I request you. Coming over back to the knockoffs. So knockoffs are purely legal. If you create a knockoff, that will not be an infringement. Now, why is that so? Because see, I told you, the very purpose of intellectual property is progress of the society also at large. If a middle class man also wants to wear Sabyasachi lehenga, and they of course can by, changing the material, but copying the design, why not? See, progress in fashion industry can only happen if these knockoffs are created, which is why knockoffs are considered absolutely legal. Rather, they serve another purpose, that they let your luxury brands, your Sabyasachi, your Manish Malhotra, all of these brands, they let them also keep their price stagnated. So they give them a tough competition, so as to say. So knockoffs are legal, but the moment you make the labels also on it of Manish Malhotra, of Sabyasachi, you make that Bengal tiger, which is the symbol of Sabyasachi, that moment it becomes a counterfeit, and that is purely illegal. Now, what if you are purchasing a counterfeit product from a shop? This retailer is also equally an infringer who is selling you the product. But if you are using the product just for your personal use, you're wearing this replica of an LV belt, that is also purely legal, and that's called fair use. The retailer might be caught hold of it, but if you have paid enormous amount of money to gain that particular thing, primarily if you have gained that particular replica or inspired, people say that this is Manish Malhotra inspired or whatever. If you've claimed these kind of things legally and you're using it just for personal use, it comes under the exceptions of infringement of copyright. So that will not be infringement. That would rather be fair use of the product under Section 52 of the Copyright Act. There are various other fair use sort of clauses under this, that if you're utilizing your work for any kind of educational purpose, for a teacher-student interaction, if you're mentioning anything, all of those are also, they would not be considered infringements. So that is it about the copyright law. We quickly come over to the Design Act now. So we have the Design Act that protects your design. And how is it different from the copyright? I have already told you before that if you have gained a design protection under the Design Act, then you will not get copyright protection over your work. Now, why is this so, and how it goes about, we'll just check. So what is a design? A design basically is having an aesthetic appeal over to your finished products. So when we talk about design, we are primarily talking about those additional fringe things that you do to market your products better. Okay, like for a pack of chips, the packet is basically your design. Okay, because it is applied to a finished product. This finished article is very important, meaning thereby the chips which are inside this packet already have a saleable value. They already have a commercial value. But just to make them more appealable, They have formed a packet over it, and that packet has a separate kind of a color scheme. Some packets are red so that they catch attention of the consumers better. So these kind of appeal based things that are added is called a design. Similarly, for clothing, what will be a design? Any kind of motif that is applied on a lehenga or a suit, that suit, that lehenga, that dress, that is already a finished product. It can be sold, it is saleable just like that. But just to add a little more eye appeal to it, we add something over to it, and that something is protected under the Design Act. Now, what is that something, and what are the features that form part of this design? They are either it can be a shape, any kind of a configuration, a pattern, ornament, colors, combination of colors, all of these things together, or one or two of these elements in combination form part of the design. Now, design is something that needs not have any artistic merit. I repeat, a design is something that needs not have any kind of an artistic merit like your copyright matter needs to have. Meaning thereby, if you make two lines on the paper that nobody has ever made in that particular fashion, you could get that protected under the Design Act. Okay, so it gives you a much wider ambit in comparison to copyright when we consider the artistic bit of copyright. Okay, but however, copyrightable matter, which is artistic matter, again, cannot be registered under the Design Act if it is claiming copyright protection. So that is there. Then designs are something that are solely judged by the eye. They can be 2D and 3D. Again, this 2D, 3D feature is similar to copyright. So 2D or 3D features, they need to be applied by an industrial process, a manual, technical, chemical, separate or combined, any sort of a process can be used to form them. So formation of it is not a problem. Plus, it needs not be functional, meaning thereby, if you've created a button, right, it has a function, no? It's going to help you loop your cloth over or whatever. But for a design, things need not even be functional. It can be just a pattern, just an ornament, just a color scheme. Those kind of things are designs. Also, design does not include under its ambit that subject matter that forms part of trademarks. And we'd go after this to trademarks, and then you'd understand why. But when we talk about designs, trademarks are not involved in and included in it. It may or may not be a mechanical device. Property marks that have been given mention under the Indian Penal Code, they do not form part of the Design Act, and any artistic work does not form part of the Design Act. Now, there's this very famous case law, which is Microfibers Inc. versus Giridhar and Company and another. In this case, the court very beautifully explained that the purpose of Design Act and the definition of design is very different from the definition of copyright and from the purpose of copyright. The purpose of Design Act is to make your creation more commercial in nature. Just like I told you, you can make more than 50 copies, sell more than 50 copies, and you would still get a design protection, right? And design protection is only granted for a term of maximum 15 years. So that is a discrepancy here again. In copyright, you were getting it for your entire lifetime and 60 years afterwards as well. But here you're getting it only for 15 years. So you have to see, if you've created a product, how would you like to protect it? Would you like to go under the Copyright Act, or would you like to go under the Design Act? Because the purpose is entirely different. This is also the reason why luxury designers, big designers, I won't name anyone, but all of these big designers, they prefer to get a copyright over their act. And this is, as a matter of fact, Sabyasachi Mukherjee, the popular designer, has over 700 copyrights over his products. So the reason he claims copyrights is also the reason why he sells everything at a much exorbitant price, and less than 50 number of pieces is entirely exactly what he makes. Had he been gone into the Design Act protection, he could have created much more than 50 and sold them. So I've explained that dichotomy to you already. Coming over to trademarks now. So trademarks are, so I have told you this, that there's a 15-year term period for your Design Act. And coming over to the Trademarks Act. So trademark, again, their term of protection, because I often forget mentioning the term of protection and I mention it much later, so I'll be mentioning this before. The term of protection under trademarks is also unlimited. Okay. Unlike copyright, where it is lifetime plus 60 years, this goes even beyond. This is unlimited. The only provision is that after every 10 years, you have to submit a certain sum of money to renew your trademark. And your trademark will only continue to subsist if you continue to use it. So if you discontinue the use of your trademark, it will not exist in its entirety, and you would not get the protections of a trademark. Now, what is a trademark? A trademark is something that can differentiate your products or your services from those of others, and it is something that can be graphically represented. Okay, so like we consider H&M. So H&M has a specific logo. You know, the H and M is written in red with a white background behind it. So all of these things form part of the trademark. What all? The color combinations, the shape, the structure, the font styles in which they are written. It can be as part of trademarks. You could write words, you could form labels, like Sabyasachi has that Bengal tiger over his name, or McDonald's has that M over it. So it could be anything. All of these cumulatively together form the trademark. Now, what is the purpose of a trademark? The purpose of a trademark is to ensure that the consumers do not feel confused. They exactly know, based on looking at the trademark, that where is this product or service coming from. So a trademark lets you know of the source of the products and services. Okay, so that's the functionality of a trademark. Plus, a trademark gets attached to the goodwill of a company. So what features does it play for the company, the firm, or the author? For them, it plays the feature of they can resource a lot of money banking on the repute that the trademark in itself gathers in the public eye. Okay, so they are banking their economic repute, they're reaping profits over the economic repute and the goodwill of this trademark. That is the purpose of it. Now, when I mentioned to you what a trademark is, there's an addition to this, and which is a very beautiful feature of the Indian Trademark Act, that it takes into its ambit trade dress. Now, what is this trade dress? It says that all kinds of shapes, okay, of goods, the packaging material, and the combination of colors that are being used can also form part of trademarks. Now there's a confusion over here, because we already studied that under the Design Act also, the shape gets a protection, the color scheme gets a protection, but mind you, these are again very different, and that was stated in this case, Corning INC and others versus Rajkumar Garg and others. In this, it was stated that both the trade dress aspect of it, the trademarks, and the design are entirely different from one another. But now, what if the shape of your product is getting infringed? Okay, if the shape of your product, which is already registered under the trademark, and the shape of the product you've already registered under the Design Act also, and now the shape bit of it is getting infringed, then which act would you prefer? Okay, then you have to, the court says, and the act says that then you have to elect any one remedy. Either you could claim infringement under the Design Act, or you could claim the infringement under the Trademark Act, and not under both. Now, that again depends upon your purpose. Just like I stated to you, that trademarks are there for literally times immemorial. So you might want to claim a shape-based feature that is getting infringed under the trademark, so that if again it happens, you could again, file a suit for infringement. So people mostly go under the Trademarks Act. How is the design bit of it different from the trademark bit of it? Because design along with shape has other features also involved, construction of lines and those kind of things. Those are not protectable under the trademark. So if in case those lines, those features, those motifs, the mukash work maybe that you've done on your dupatta, if that is getting copied, then you'd have to go under the Design Act itself, right? And if your trademark gets infringed, then you go separately under the Trademarks Act. But if the shape gets infringed, then you have to elect a remedy, whether you want to go under and seek the remedy under the Design Act or under the Trademarks Act. Now, trademark is territorial in nature. However, there are territorial meaning. If you've registered your trademark in India, it is available only in India. You have to register it separately in separate countries if you want protection from all of those countries also over your trademark. But there are certain well-known marks. Now, these well-known marks are extremely reputable marks, and they are reputable based on their usage, based on their common prevalence and parlance across the borders of the country where they have registered their trademark. And these kind of marks get protection literally everywhere. Okay, so what are these marks again? Marks like MS, okay, marks like Sabyasachi again, these things are well known. Marks like H&M, Zara, these are well known trademarks now. So which is why even if they do not claim protection under the Trademark Act, they are unregistered in a country, they would still get optimum and even more than optimum protection. How? Because there's a feature called deceptive similarity. So when somebody creates a deceptively similar trademark, that is called infringement of the trademark, right? Now, but there's also this provision, because I told you the government has to maintain a balance between public good and the monopolistic rights of the trademark owners and all of these other people. So what the government has done, what the legislature has done based on this Trademark Act, they have created a provision that says that deceptive similarity makes it infringement. But if somebody is using the trademark, the similar trademark or a deceptively similar trademark for any other kinds of goods and services than what this registered trademark was using, that will not be considered infringement. I know it sounds tricky and tough, so I'll take an example to explain you. Since we discussed about Biba and Ritu Kumar, I'll take up that similar example. So if we consider the word Biba, okay, they have a trademark, they have a flower logo, it's written in white over a red banner, and it is copyright, it is trademark, it is protected under the trademark. Now if somebody copies their name Biba and uses it for, say, outside the fashion industry, say for example for manufacturing of sweets, okay, so I'm a seller of sweets and I title my shop as Biba, can I get my trademark registered? Of course, with different color schemes, some innovations within the trademark. The answer is yes, because the field is changing. The goods and services that I'm selling are absolutely different from that other Biba. So this has been ensured because the legislature knows, that the public knows that this Biba is the apparel-based Biba and this Biba is the sweet seller. So they can distinguish this, based on which this has been there. So this will not be considered infringement. However, if we copy paste the names of well-known trademarks, that would still be infringement, even if we copy paste them in an industry outside the industry of the registered trademark. Again, an example of this is if I take H&M. Okay, it's a well-known trademark in India. Its prevalence is there here in India. Everybody knows of it. Now, if I copy paste it and start selling crockery, for example, it's an entirely different industry from the fashion industry. And here I sell it and title it as H&M crockery. Okay, I will not get a copyright over this because this is already a well-known trademark. Or let's say Fendi. Okay, Fendi is so popular, people have started naming their dogs Fendi as well, right? So if we have Fendi, it's a well-known trademark. Now I use it and say Fendi dog foods. Okay, so that will not be considered and registered because Fendi is a well-known trademark, and its dilution and its deceptive similarity is considered much more than others. So that will not get registered at all. Now again, is registration mandatory for trademarks? No, the answer is no. It's not mandatory. However, if you register your trademark, you get an added protection here. In copyright, if you register, you don't get any added protection, but here you get an added protection in the terms of a passing off remedy also becomes available to you. Now, what is this? Usually, in all of these many varieties and subjects that I've mentioned to you of intellectual property, what is the claim that you can claim from the court if some infringement is occurring? These are all civil law remedies that you can claim from the court. It can be granted to you in the form of an injunction. It can be granted to you in the form of a profit sharing ratio between the one who's copied your work and yourself. You could get a share of profits from what he has gathered. Okay, and you could get certain damages. So these are the provisions. Okay, if any infringement happens under the trademark, under the copyright, under the patents, etc., which we would be studying further, these are the remedies available to you. However, if you register your trademark, you get one more additional remedy available to you, which is called the passing off remedy. This is a common law remedy that has been created out of necessity, and it is used in precedents a lot. And what this common law remedy does is, if there's a claim of infringement of a trademark, it goes much deeper into and checks into who was indeed using this trademark previously. So it considers prior user as the person who indeed has claims over the trademark. If two people are using the same XYZ logo, the court is going to go, and both of them are unregistered trademarks, for example. One XYZ goes and sues the other XYZ trademark company in the court of law. The court will then take up the passing off law remedy, and they're going to consider that which one was indeed the prior user, and the one who was the prior user is going to get the claim of infringement, right? And the other person will of course have to do some profit sharing and those kind of things. So if you register yourself, you get both of these remedies. If you unregister yourself, if it is an unregistered sort of a trademark, then you don't get all of these remedies. Then you only get a passing off remedy. The court will only check whether you were a previous user or not. But if you are a registered trademark, you would get a statutory remedy as well. You could get damages, you could get injunctions, you could get profit sharing, and you could also, along with it, get this passing off remedy, right? So with that, Asha, also I must tell you that when we're talking about trademarks, what will be a registrable trademark and what will not be a registrable trademark. So a trademark needs to be very distinctive. What we mean by distinctiveness is it should be a very unique word, an inventive word. It should not be a descriptive word. It must be a suggestive word only of your products. Now, what does this mean? First, I said that it should be distinct. How would you consider that a term is distinct or not? It should not be used by the general public. That is how you would consider it distinct. For example, McDonald's. McDonald's is a pronoun? It's a noun rather. It's a proper noun. So it is distinctive in that particular category. So it is not used. It's not publici juris. Publici juris meaning that not everybody knows of that term. Okay, what words are publici juris which you cannot use as part of your trademark? For example, words like sukh and dukh. For example, words like ananda. This is an actual case law where the term ananda was considered publici juris by our courts, and it was not granted trademark. Okay, it was not registered as a trademark. So these terms are called publici juris. Now I told you that the words need not be descriptive. What is descriptive? That you're opening a fashion label and you're calling it fashionable, okay? Or you're calling it fine quality products. These are what? You're just using adjectives for the products that you're selling. So this is not quite suggestive. It is absolutely descriptive as a word, and they cannot be registered as a trademark. Your word needs to be merely suggestive. Okay, for example, rasna. I know this is something beyond the fashion industry, but this is an actual case. Rasna is considered, rasna is the beverage that you drink, and it is considered a suggestive word. Okay, and it is granted a trademark because it says that it is a combination of two words, ras and na, and that makes it a very novel sort of a word. Okay, so you have to keep that in mind while registering your trademark, that it needs to be novel and absolutely distinctive. Then domain names, which are your website names, those headings that come after the www. Take a www, India Times or indiaproperties.com, these kind of things. .in, anything, the extension can be anything. So these kind of domain names are also registrable as a trademark. And why have they become registrable is, of course, because they are also gaining more importance. Now we're living in an e-commerce sort of a world, and people recognize websites by their name as well. So this is why these are also protected. And the only rider to protect your domain name under the trademark is again the same as I stated. It should not be a word which is in any way descriptive. It should just be suggestive of your product and not descriptive of your product. It should have relevant distinctiveness added to it. So that is it about the trademarks. One more thing. In trademarks, there's another provision. So we spoke about infringements of trademarks and how would then you be granted your rights if trademarks are getting infringed. But alongside infringement, there's something called dilution of a trademark as well, which has been mentioned in the Indian Trademarks Act. And what is this dilution? And this is, of course, piece of information for anybody who's a content creator online or wants to wear brands and tag them. You should know this piece of information. Dilution of trademarks is when, by usage of advertisements, print media, social media, any other forms of advertisements, you are trying to lay disparaging remarks, okay? The remarks which oust the repute and respect of a certain brand. If you're doing that, that will be called dilution of a trademark, and you, whoever it is that's doing this particular thing, can be entrapped as diluting the trademark. And the similar civil remedies are available for such kind of dilutions also. Either you will have to give a share of your profits if you're earning certain profits by doing so, or there'll be other punitive measures, that fines, etc. They are also there when it comes to dilution of trademarks, right? So so as to say, of course, there's something called comparative advertisement, that you're saying that this is better than this, you're showcasing that. But when you say this is better than this, you cannot really say the name of the opponent. You cannot say the name, the brand name, or you cannot use the trademark of this other person. So if, for example, let's take the example of H&M and Zara. Okay, if a fashion blogger comes up and says the quality of this t-shirt, I bought it from H&M, is very nice, that's fine. If she says the quality of this t-shirt which I bought from H&M is very nice than all other prevalent brands of the same price segment, this is also comparative advertisement, and it's absolutely legal. It will become disillusionment and dilution of the trademark the moment this content creator or fashion blogger now says, I bought this piece of t-shirt from H&M, and I bought this same piece of t-shirt from Zara, and you can see which is better. You know, this is better. So the disparaging remarks can be as subtle as this, that she's showing it to you for you to witness and predict, but this is in turn delusion of the trademarks of Zara, and they can claim multiple suits and multiple legal remedies based on this. So this is something that you should know when it comes to advertisements. Coming over to the next topic now, which is patents. So patents in India, we grant patents both for products or for processes. Now, what is a patent? A patent, again, is a very monopolistic right that is granted to the creator of an invention. Okay, so just like copyrights are granted for artistic works, these are granted for inventions. Okay, now what is an invention? What is the product or what is the process that will get patent? It has to be three things. It has to be novel, meaning that it has to be absolutely new. It should not be already in public domain. That is, that people should not have been aware of that particular invention that you have brought about now prior to you getting it. Okay, so it should not be in the public domain. It should be novel. Second, it should have a kind of an inventive step or a non-obviousness element added to it. Now, what is non-obviousness? Meaning that people who work in the same fraternity or in the same industry, whose product is this that you've created now, or whose invention it is that you've created now, they should also not have felt that this invention is very obvious. Okay, for example, if we consider pharmaceuticals, if you're creating a drug, it should be absolutely normal. It should be absolutely novel. Other pharmaceutical companies should not have felt that, oh, this was a very obvious kind of a creation. We were already working on it. Okay, so this is called inventive step or having non-obviousness. Then you should have some industrial application to it. So a patent will only be granted to you if you can actually suggest this and disclose this as part of your invention and your patent application, that this piece of invention that I've created is actually going to be useful to others, and it can be produced in multiple numbers by such and such process. So for a patent, you have to disclose that entire process with such clarity that anybody who's not even extremely competent about that field is able to understand what you've written and even replicate your invention. Okay, so a patent then gets granted to you if you prove these three steps: novelty, inventive step, and industrial application or utility of it. You will get a patent over your product or your process, and with your patent, you get a monopolistic right, your economic rights, your other kinds of rights for 20 years. So the term period is 20 years. After 20 years, it's going to pass on into the public domain. And after that, anybody else can utilize it. It will not be infringement. Anybody can copy it. It will not be infringement. Just a moment, please. Coming back to patents now. So when we talk about the fashion industry, what is the importance of patents in the fashion industry now? So things like a Velcro. We all know what a Velcro is, right? It is applied to various fabrics and it acts as a clasp. You can close the, it can be used as an alternate to buttons and so many things. So it's just a clasp and it's called a Velcro. And this Velcro was indeed patented in 1958. So now it's not a patented invention anymore. It is a part of public knowledge, and which is why we commonly get a Velcro for like 5 to 10 rupees. But initially in 58, when this was created, it was a huge invention, and astronauts were wanting these kind of Velcros for their dresses, and they were paying hefty amounts to purchase a single strip of Velcro. So this is the importance of patents in fashion law, that if you're creating a very novel sort of a textile or a very novel sort of a clasp, you can get certain patents over it. A very recent example of this is there's an apparel with pockets over it. It's the patent name is only apparel with pockets. Now, what is this apparel with pockets? It's a US-based patented invention pertaining to fashion law. And this particular cloth piece or this particular apparel, this dress, it has a huge pocket to it, which is adapted in such a way that it is not seen by the naked eye. Of course, if you see it closely, only then will it be visible to you. But it can be adapted to receive a beverage can into it. So you could put a glass of whatever, a can of or a pet bottle of Coke or Pepsi into your dress, and otherwise the pocket is not even visible. So this is a patented invention. Then Velcro, I've told you. Then there can be multiple kinds of insulating fabrics that are created. Now, what is an insulating fabric? That is like so delicate to touch that it doesn't seem it's going to protect you from a lot of wind or breeze, but it in turn does. The technology that goes inside making it is of such a nature that it is insulating indeed. So one of the patents which are based on the similar idea, it's called Kevlar. So Kevlar is an insulating fabric, right? Coming over to an important case law here. So we have Spanx versus Yummy Tummy. Spanx and Yummy Tummy, these are both innerwear brands, and they created those bodycon sort of fitwear for women. And of course, both of them were claiming that we created this beforehand, and we have Spanx was basically saying that Yummy Tummy has infringed my patent, but Yummy Tummy was indeed able to suggest it to the court based on evidence that they created it much before Spanx created their own invention and got their patent. But since Spanx had a registered patent, of course, Spanx had claims of infringement over Yummy Tummy. But what these two parties in turn did was they took it to outside court settlements, as I told you before, because when it comes to patents, legal battles can go on for much longer, and then you'd have to give out literally all your secrets out to the public in the court of law. So which is why parties preferred arbitration and settled it outside the court. So this is what happened. So this is a patent for you, very short and crisp. If anything new is there, any invention is there, which has an industrial applicability for the better use of the public, that can be patented. Now, there are various other subject matters that are not patentable. What are those? That it should not be, and it's not related to the fashion industry. It shouldn't be something that's naturally occurring as a substance. So, for example, formation of curd cannot be registered as a patent because the milk curdles itself. Okay, there's no sufficient amount of invention involved into it. So these kind of things. Patents cannot be granted for frivolous things. Now, what are frivolous things? And this is the exact same word used in the act. I'm not using it otherwise. Frivolous inventions are like a popsicle, okay, like an ice cream popsicle. It's absolutely frivolous. Or you've created a very shiny sort of a design over your fabric. Okay, it has no functionality, it has no inventive step, it has none of these three things: novelty, inventive step, industrial application. It's absolutely frivolous. Okay, so these kind of things. And there are many others, that it should not be obscene, the subject matter should not be obscene, the subject matter should not be against the public order and morality. And basically this public order and morality and the subject matter should not be obscene goes on not just for the patents, but for all other things that we have studied so far. For trademarks also, the things cannot be obscene. For your copyright also, for all of these things, for design also. So that is patents. Coming over to the next, which is trade secrets. Now, trade secrets, as I mentioned earlier to you, is a part of intellectual property rights, and it is not protected by a legislation. So it has not been reduced into a codified law, but it exists in the form of common law remedies in India, and in certain other countries, of course, it is codified. In India, by far, it hasn't been codified. Should it be codified? Yes, it should be, to provide better protection. Now we'll see what is a trade secret. A trade secret is basically all kinds of confidential information that make your business profitable to you. Okay, or that make your works of creation profitable to you. That's a trade secret. Confidential information. And how are trade secrets protected in India? We often have the employers getting the employee to sign non-disclosure agreements. So in these form of non-disclosure agreements, we protect our confidential information. Okay, these non-disclosure agreements can be a separate agreement that the employee has to sign, or it can be a part of the employment contract of them only. It can be just one clause of it. Okay, so this is the way we protect trade secrets. Trade secrets have to be differentiated from trade knowledge. Now, what trade secret entails and what trade knowledge entails? Trade secrets entail all kinds of client details that you've had on your laptop. That is a trade secret. Or the recipe that you created in formulating something. That is a trade secret. Or in cases of fashion industry, like Anita Dongre, she's also an affluent fashion designer and a known name in the industry. I saw one of her episodes on Netflix, and she stated that she gets all her inspiration from Jaipur and from all of these artisans. She has employed all of these artisans over to work for her. Now, where she gets these artisans from, where she gets her inspiration from, all of these things are her trade secrets, which of course the employees that work for her already know of, right? So the moment they leave employment, they come to utilize those trade secrets for their own benefits. Okay, so that is wrong. That what an employee after leaving employment, if he or she is using these trade secrets for their own benefit, that ousts the rights, the economic viability of Anita Dongre or any other fashion designer in this particular regard. And I have a similar case in hand. So the case law is Good Earth versus India Circus. In this case, Good Earth is a crockery brand. It's not pertaining to the fashion field, but it's a relevant case law on point. So it is a crockery brand that designs crockery in such a way that all its crockery has some quirky pieces and designs made over it. Now, they had this one person, Krishna Mehta, working with them as an employee. Krishna Mehta left his job and formulated another brand, another crockery brand of the same idea called India Circus. And he started replicating the designs of Good Earth and rather utilize some of those designs also, which were not in public domain, which Good Earth had saved on their systems. They haven't created a crockery out of it. They had just saved those kind of works. So he utilized them also. So this is a part of trade secrets. He has ousted the confidential information and the trade secrets. Okay. So if trade secrets are breached, you could approach the court, only when you had taken actual measures to protect your trade secret, meaning thereby that you need to have contractual application of trade secrets. Only then, if there's a breach that occurs, can you go to the court. If you do not have this contractual implication, or even if you do have, there's another provision available, which is a penal Indian Penal Codes provision, and that is called criminal breach of trust. So the infringer can become party and can be involved and entrapped under this legal provision as well, which is called criminal breach of trust. Now, this is the entire bit of trade secrets. Now, I told you that trade secrets, if somebody goes out, utilizes, this will be against the rights of the owner, the author, and the original creator, and this is absolutely wrong. And we can have legal claims over this. But what is trade knowledge? And if somebody, this is a matter of fact, utilizes his trade knowledge after leaving employment, that will not be considered breach of trust or breaching of any kind of confidential information. Trade knowledge is the skill that I gathered working in a particular firm, or working in a particular brand, working for a particular brand or a company. Like, I learned how to make PowerPoint presentations. Very simple. Okay, I worked under a fashion designer, and I learned a few techniques how to present the work better on certain softwares. Now I utilize my own skill and utilize the similar softwares after I leave my employment and work on a similar kind of a project. That will be considered trade knowledge and not trade secrets, and that is absolutely legal. Because if we would have contracts stating that you being the employee cannot even take away any kind of skill or trade knowledge after you leave this company, those will be considered agreements in restraint of trade again, as I mentioned to you, which is a part of Section 27 of the Indian Contract Act, and it is absolutely unlawful. These kind of contracts are void, so you can't have a contract like that. Also, to tell you that trade secret law is called the Cinderella of intellectual property rights, because it was a very late bloomer. So all of these other rights, trademarks, patents, everything were in place, but trade secrets was realized as being part of the intellectual property rights much later. And this was actually created to be an alternate for the patent system. So for the people who really appreciate trade secrets and the proponents of it, they often say that, within a patent, if you get a patent protection, you get it only for 20 years. But if you protect your invention, you do not disclose it to the patent office. Okay, you do not get a patent over it. You just maintain your confidentiality with all of your employees properly via contracts. So that will become a trade secret, and the trade secret can literally be protected for hundreds of years to come. So this is what they say. And a very eminent example, again, it is not from the fashion industry, but very relevant, is of PepsiCo. So nobody until now also knows their trade secret and the recipe that goes inside making Pepsi. Okay, and even Coca-Cola for that matter. Coca-Cola also is something, the recipe of which people don't know of. So it's the best. These are the best two examples of trade secrets well protected. They haven't gotten a patent over it. These are trade secrets, and they've been going on endlessly. So with that, we finished the major chunk of intellectual property. And just to tell you, we have another bit of it left, which is called the geographical indication. And geographical indication is nothing but these are rights that are granted to a certain state or to a certain place where people use traditional knowledge, that is knowledge that has been passed on to them from their ancestors, to formulate something which is again a creative work or an invention or anything. So those kind of things, they get a geographical indication over them, and whoever after that utilizes that particular geography related invention, they either have to give all of these people, the artisans of that particular place, some amount of profit sharing or some amount of respect and recognition. Okay, just like in our exams also we can write anything, or just like in our speeches or research works also we have to write anything, but in order to avoid plagiarism, what we do is we mention the name of who stated such and such in the footnotes, right? Similarly, recognition is a big thing. So if you're providing recognition and a part of profit sharing to all of these people whose knowledge is it that you're using, it'll not be infringement of anything and any kind of intellectual property rights. So an example of geographical indication is like the Rasgulla. This is still a very heated debate whether it belongs to Bengal or Orissa. So this is actually a case ongoing in the court of law. So that is it. And geographical indication, when it comes to the fashion industry, we have so many things. No, we have Banarsi saris, we have Jaipuri work, we have all of these varied kinds of works coming from all kinds of all parts of India. Right, we have those famous red and white border Bengali saris. I don't know what are they called, but all of these things, I think these are subject matters of geographical indication. And if you're forming that kind of a Bengali sari under the label of your name, for example, if you're the designer, you have to mention that this is taken up from them. If you're getting it made from those artisans, you must as well share your profits with them. So this is the entire bit of geographical indication. And with this, I hope you've gotten some information and some insights into how can you yourself, without even approaching a lawyer, can protect your creation better. And you've gotten an insight into what intellectual property actually looks like. Of course, everything cannot be discussed in absolute detail. So I tried to keep it as concise as possible and as inclusive as possible. And rest everything, I'll think we'll start with our question answer session. And if you want to ask anything from me, we'll take it up from there. So team Lawtraction, the moderators.
Oh. With your permission, ma'am, can we start a question answer round?
Yes, please, absolutely. Let's begin.
Okay. So the first question is from Harshit Verma. He's asking that, ma'am, you have provided an example regarding how rights are balanced with respect to intellectual property. Can you please elaborate on it?
Okay, so I told you this as the purpose of intellectual property here in India and actually everywhere else. The rights need to be balanced. Now, what are these rights and how are they balanced? I'll go in detail. So the person who's the creator, the one who's creating something, has certain monopolistic rights, of course, because he himself has produced that particular thing with his labor, with his skill, with his own money also can be involved. Sometimes capital can be involved. So now this person has produced this something. Let's take the example of a book writing, because you'd understand it better that way. If somebody has written a book, okay, he's the author of a book, he has created that for the knowledge of others, okay? So he gets, it took him a lot of skill, a lot of effort to write that. So he gets economic rights over it. He's the one who decides who will be the publisher. He's the one who decides how many translations of my book can be made, in what all languages can it be made, right? But at the same time, the government ensures and the legislature has ensured with the provisions of copyright and all of these other acts that a balance is maintained between the general public good and the monopolistic economic rights of this author. Meaning thereby, if the government feels that this book indeed has knowledge that needs to be dispensed in the whole of the country, and not everybody in the entire country gets English, which is the medium in which this book is written, they can make compulsory licenses available to other publication houses to make translations of this particular book in Bengali, Bangla, Urdu, in all kinds of regional languages. So this is how the legislature ensures, by the way of compulsory licensing, which is a kind of flexibility that is available under the law, that the public good is also ascertained. Another way how public good is ascertained is, which is the last step, that there is always a term of protection available. Like I said, copyright will stop subsisting after you've died and after 60 years have elapsed. After that, it comes into public domain, right? So this coming into of public domain is also how the public is granted its rights and the balance is maintained. Patent similarly becomes something of the public after 20 years have elapsed. So this is how. It should be purposeful to both the person who's creating it and to the country's GDP and to the general public. This balance the government maintains by certain sorts of interventions or by legislation. Next question, please.
The next question is, what is the significance of intellectual property in fashion industry?
What else have we discussed throughout? This is it. I cannot repeat the entire 1 hour lecture. So
yeah, I'm sorry, this is the half of it. So it is continuing with it that there is a possibility of clashes between fashion law and media law. So, like if an overlap of fashion law and media laws, then what will be the consequence of it?
There'll be no consequence of it. I have already mentioned where in fashion law the media law becomes part of. I mentioned when I was discussing copyrights with you, neighboring rights, right? So if a fashion designer has created something and now, the Lakme Fashion Week, for example, is happening, that gets captured. So who's capturing it? The media is capturing it. Now the media has certain rights, okay? Then, so they cannot mutilate the creation, they cannot mutilate the faces of the models, everything, those kind of, negative rights also they have. And then they have certain rights to keep those recordings with themselves, to make electronic reproductions of it, because they were the ones who captured it and all. So these are neighboring rights. The models have these neighboring rights. The broadcasters, since you asked about the media law part of it, what comes to my mind is the part of the broadcasters. Now who's the broadcaster? Say Z News or Z TV is showing that this fashion show happened in this place, right? So they are the broadcasters. So how many times can they broadcast it? Because the reproduction rights are with the designer or the director of that fashion show, right? So, but these broadcasters also have some rights, and those are called neighboring rights. They are also dealt with under the contract law. So you have a contractual interaction with all of these people of the media personals, and this is the amalgamation of media law into fashion law. And media law is studied quite separately also, because that includes your social media advertising and basically the e-commerce part of it much in detail than how we study it in fashion law.
Okay, so shall I take the next question, ma'am?
Yes.
So the question goes like this: if I am a librarian of a public library, there is a book which is not available in India. I made 10-20 copies of this book for use of public library. Is it going to be an infringement under Copyright Act?
It is going to be an infringement under the Copyright Act, because as I mentioned, under fair use, which is section 52, it mentions a clause that in libraries you can keep the books, but you can keep 1 to 3 books. 3 is the maximum limit, okay? In electronic form also, you can keep it on 3 systems. Beyond that, if you're saying 10, 20, how many copies are you saying? How many copies does
10, 20.
10, 20 copies you can't keep. You can keep 3 copies. Anything beyond that can be considered infringement. That depends upon the claims that the person who wants to file the case is making. It depends upon that. So this will not be fair use. For educational purposes, however, things can be replicated of international authors also. There's a very prominent case called the photocopy case versus Delhi University. So you could go and study that up on this particular matter. And but 10 to 20 copies, yes, it is infringement. It is not fair use. I hope that resolves.
Okay. So as you stated that civil remedies is against the violation of rights. So there must be remedies like injunctions and damages available in the cases of IP infringements. So is there injunction and damages available in IP infringement?
Yes, these are civil only. I didn't say that civil remedies are, these are what are civil remedies. There's a differentiation between civil and criminal kind of remedies available for anything. So having injunction means what? To ask this other person to stop acting the way he's acting right away. It is a civil remedy. It's not criminal in nature. What will be criminal in nature? Something that has a fine imposed on it, or something that is punitive. We have provisions of fine when we talk about trademarks, a certain bit of trademarks, when we talk about dilution of trademarks, right? So those kind of things. But otherwise, these are all primarily civil remedies only. Injunctions, damages, compensation, profit sharing, these are the remedies available.
So someone has asked about the hairstyles. So like someone comes with a really fancy way of cutting and tying the hair. Are they covered into IP and fashion laws? The
They can
hairstyles of
be,
that.
yes. The hairstyling bit of it, the cutting technique basically, okay, or its formation, its application in a 3D form. It can get copyright, as for me, because it's not patentable, right? It's not an invention that has a maximum industrial style or utility in that particular regard. I think copyright is your answer.
Okay, so this was the last question. And everyone who are the law aspirants, they're keen to know about the scope of fashion law in India. So you can just give a bit about it.
Yes, please. So, see, the scope of fashion law, I think it's ongoing. And as an IP professional and as an IP student, also, every time I used to hear that IP is still a growing field. It is a much newer sort of an industry. But I don't understand why do they say that? Because IP laws have been here literally for quite some time now, for more than 200 decades. We had the Indian Penal Code also here for us in the 1800s, and we had trademarks also in the 1800s itself. So I don't understand why is it still called a very progressing, a slowly upcoming field. It is a field, it is very well here. So if you want to take up intellectual property, especially things like media law and fashion law, I think there's a lot of scope. And see, there are master's courses existing in these kind of fashion laws. That is itself proof that this is an ongoing field, no? Which is why a specific course has been created for it. So there is definitely scope. And if you want to enhance your scope and still be under the ambit of intellectual property, pursuing your master's again under intellectual property and dealing with an intellectual property matters as a whole is much more viable in that particular case.
I'm so sorry, this one question is left.
Yes,
They
please,
are
absolutely.
Thank you. So the question is
It's okay.
I'm so sorry for the disturbance.
Okay.
So the question is there any period of limitation for registering any product?
Okay, so when we come over to registration, I'll just quickly run you through with the registration procedures of all the subject matters. So when it comes to copyright, we do not require to register it, as I told you, but it can be registered at any point in time. Even if you have made a lehenga, sold a few copies of it also, you could still register it. However, if you talk about the Design Act, it has to be registered. As I told you, a design has to be novel, new. It should not be known in the public domain. Okay. So if you have created a dress and you've sold one single piece of it also, and after which you want to get the protection under the Design Act, you cannot get protection under the Design Act. You cannot get it registered only in the first place, because after you have sold one copy, it becomes public knowledge. It does not remain new or novel. So the limitation period when it comes to registering your design under the Design Act is that it should be absolutely normal, absolutely novel and fresh. It should not have been used and utilized anywhere. So that is one. Then when we come over to patents, again, there's no time limit of registration. The only thing that is known to us is that it has to be novel. Okay. So if already somebody, you didn't register your patent for 5 years, you were utilizing it and creating certain equipments and selling them. Okay. But somebody seeing your product reverse engineered that product. Okay. In the sense, like, for example, what is reverse engineering? I'll explain it in brief. If you're tasting some dish, so you figure out that, okay, these are the ingredients involved in it. You try replicating it and you're indeed able to replicate the exact same dish. Okay, so that's called reverse engineering. So if you don't go in for patents, this is the only fear, that somebody can reverse engineer it. So that is the time period available. Register it as soon as possible to get maximum protection, at least for 20 years. So that is it for trade secrets, of course. Since there's no law, there's no, of course, it's based on confidentiality. There's no registration clause only available. For trademarks, again, there's no time frame for registration at all. Okay, you could go on using your trademark for more than 100 years, and now you're choosing to register it. That's very well possible. So there's no limitation for registration. However, if you register, you get much more remedies if infringement is occurring. That's the only purpose of registration.
Thank you so much, ma'am. So over to you, Sandra. for the
So that's
vote of
all.
thanks.
No other questions?
No, ma'am, no more questions.
And even though any of you, after watching this session, have any further questions, you could contact Team Lawtraction. They're going to contact me again, and I'm going to resolve your queries. You are more than welcome to approach me on my Instagram as well, or my LinkedIn account if you have any further queries regarding fashion laws or intellectual property. So thank you, Lawtraction, for having me over.
Thank you, ma'am. So over to you, Sandra.
Right.
With this, we end of the session. I'm privileged to thank our esteemed speaker, Advocate Nishtha Sanduja ma'am, by taking our valuable time to guide many law students by providing such an informative and enlightening section on fashion law in India. Thank you, ma'am, for making
I think she's having bad network issue. Let me conclude then. Let me conclude. So I would like to thank our esteemed speaker. Our esteemed speaker, Ms. Nishtha Sanduja.
I think there's this discrepancy that she's also trying on endlessly. It's okay. It's fine. It's okay.
Okay, this will come to end of the session. I wish to thank our esteemed speaker, enlightening section on
I think there's some technical glitch coming. So it's
I'm so
okay.
sorry for that.
And, absolutely fine. I'll only give the vote of thanks. We have
No, I give. No, ma'am, I give.
It's fine. We have come to the end of the session, and I was thrilled to be over here with you. It was quite insightful, especially, you know, what I love the most about these kind of sessions is when I get questions and I have to answer them. The lecture bit of it is not so interesting, but gaining insights from what you guys are, making out of the session is what I like the most. And thank you, Lawtraction. And thanks. It was a great association.
Thank you so much, ma'am. So let me complete, please.
Okay,
it will be a baggage then.
No, please. That's absolutely fine.
Yeah. So I would like to thank our esteemed speaker, Ms. Nishtha Sanduja, by taking out her valuable time to guide many law students, lawyers, by providing such an informative and enlightened session on learning the emergence of fashion law in India. Thank you, ma'am, for making this event interactive and full of knowledge. Thank you to our mentors, Ms. Sardev Singh, Mr. Abdul Qadir Pasha, and Ms. Bhumika Sharma. I would also like to render my heartfelt thanks to our organizer, Mr. Avinash Gautam, Mr. Akshit Malav, and Mr. Hasimuddin. Their robust energy, guidance, and enthusiasm, without which this event was incomplete. And at last, I would like to thank Lawtraction virtual volunteers who has managed this event very successfully. Thank you to all participants by participating in this event, which has always encouraged us to organize more events like this. We have a great time with you all. Thank you. Thank you, ma'am.
Thank you. Bye.
Bye.